Exactly. So let's officially get started. Welcome, everybody. So excited to have you all in class today. My name is Curry Sutner. I'm the Chief Learning Officer at the National Constitution Center. And we are hosting yet again another amazing Friday session for our new students and our returning students. We are excited to have you today. And today is the final week on the First Amendment, but I'm sure Jeff will make sure that we always engage with the First Amendment every week because it is so important. So if you have questions during class, feel free to ask them. Put them in the Q&A, put them in the chat, and Jeff and I will make sure we weave them into the conversation with our fantastic guest scholar today, Zach, who is here with us from FIRE. And without further ado, I'm going to turn it over to Jeff Rosen, our president and CEO at the center, to kick us off and to formally welcome Zach.
Well, thank you so much, Curry, and welcome, Zach. It is such an honor to have you. We are so lucky at the National Constitution Center to be your neighbors. FIRE is located in Philly, right near the NCC, and I'm so excited to introduce you to our great class because the work you do at FIRE in defending the free speech rights of students and teachers and Americans is so urgently important. So thank you so much for that work, and thanks for joining us on Friday.
You got it. I am happy to be here. It is similarly an honor to be associated with the National Constitution Center, and we appreciate all the good work you do as well, educating the American people about their rights.
Thank you so much, Zach. Well, we have so much to talk about. Of course, there's so much going on campus involving free speech and assembly and petition, but I thought we'd begin maybe by just reviewing the core text and meaning of the assembly and petition clauses. They're less familiar than the free speech clauses. So I know I at least have fewer occasions to encounter them, but why don't I try to call them up on the interactive Constitution, because there's some great explainers about them. And as I do that, maybe you can introduce our friends to what the core meaning of the assembly and petition clauses are.
Sure, I'd be happy to do so. They are part of what we consider to be the core 5 freedoms of the First Amendment. This right to assembly has always been an individual right, but also a right that we can use to get together with groups of individuals to express ourselves. It is most commonly looped in with the right to free speech because it is used by individuals to associate in a wide array of economic, political, and social ends. An individual's voice is very important. It's what we want to hear, but adding your voice to your fellow citizens, to your fellow group members, banding together to further a common objective, that's where we get some really powerful expression, and that's how we affect change in our society. Petition, similarly, is a method under the First Amendment that we can affect change and express ourselves. And this is a traditional right. It goes back centuries, almost the Magna Carta to the English common law, about the right to take your viewpoints, to take your grievances, your gripes to the authorities, to petition the king, to get in front of the decision makers of our society and to ask them to right or wrong, to correct an injustice. And this right is essential in the First Amendment because it prevents the government from punishing you, from jailing you, from tallying against you for bringing your grievances and your petitions to the government. So these are 2 core First Amendment fundamental rights, and they're not quite as popular or as talked about as the freedom of speech or freedom of religion, but that they're still essential parts of the First Amendment.
That was such a great introduction. You so well summed everything up, and several of the same precedents you noted are on our interactive Constitution explainer. This is by John Inazu and Bert Newborn, and this is their common statement about the core meaning of the 2 clauses. And we'll just read them because it's always good to get the text. It says, Congress shall make no law respecting the right of the people peaceably to assemble and to petition the government for a redress of grievances. And I want to focus on 2 parts of those clauses, especially the idea of peaceable assembly and also that language about petitioning the government for a redress of grievances. Why don't we start with petitioning the government? The interactive Constitution explains, as you said so well, that this dates back to English common law and was explicitly protected in the English Bill of Rights in 1689. So it was something that the Whig writers who the framers relied on cited a lot. And in Cato's letters, they talk frequently about petitions to Parliament. By the Bill of Rights and the Act of Settlement of the Revolution, a right is asserted to the people applying to the king and to Parliament by petition and address for a redress of public grievances and mismanagements, when such there are, of which they're left to judge. The reason I'm excited is because that was like a cold search. I wasn't sure that Cato's letters would actually contain the phrase redress of grievances, but it did.
Yeah.
I've been so, well, tell us more about that. I've been so struck by how much the framers are quoting from Cato's letters, but what's going on there?
Yeah, it's interesting, the history, the context behind these rights. You have the framers, the founding fathers. They were operating in an era that wasn't too far away from the medieval era, right? We're talking about 1700s, right? Going back to the Magna Carta, right? 1215. We're talking about an era that was known for individuals bringing their grievances to the kings, the bishops, the barons, the counts, all the sort of, authority figures back then, and being punished for it, having them, their families jailed, having their lands confiscated. Really, it's the background of people petitioning and complaining to the authorities and petitioning for justice and being punished for it. And so these framers, these individuals said that, look, this has to stop, right? This has to be something we can do. We shouldn't be able to fear for our lives and our livelihood simply by issuing a complaint, by bringing attention to injustice to the king, to the government, to the authorities. So the right to petition really goes back to this notion that merely expressing yourself and merely bringing to the attention of the powers that be these injustices in our society should not be a punishable offense.
Beautifully said. And as we also note, and as you mentioned, the Declaration of Independence explicitly notes the fact that King George ignored the petitions of the colonists as a grounds for revolution. It says that it was explicitly called out in the Declaration. And then other famous examples of petition, of course, John Quincy Adams provokes a near riot on the House floor by presenting petitions from slaves seeking their freedom. The House leadership responds by imposing a gag rule limiting petitions, which is repudiated as unconstitutional by the House in 1844. That's so cool.
Yeah, interesting. My favorite story is how the Continental Congress, second one, submitted the Olive Branch petition to King George III, saying, "Hey, this is kind of our last chance here, our last way to reconcile and to create peace and kind of mend the broken bond between colonists and the monarch here." And King George III responded with a declaration of rebellion, saying that, all right, this whole thing is illicit, it's illegal. You guys are no longer part of this empire, and we're going to use our armies and use our military to destroy you, to hang you. So it really shows the background of this right. Colonists saying, please redress these grievances when it comes to taxes and representation, and King George saying, we're going to kill your whole family. So it's really no secret at all, really no dispute at all why the colonists thought it was really important to include the right to petition right there in the First Amendment.
Wonderful, thanks. What a great story about the Olive Branch petition. Well, now let's talk about the right of assembly, and I'm going to ask you a question that I don't know the answer to exactly, which is what the importance of the word peaceable is. Of course, the framers are very concerned about violent mobs. They come to Philadelphia and create the Constitution because they're afraid of mobs like Shays' Rebellion, which mobbed the courthouses in Western Massachusetts and tried to shut them down. At the same time, they recognize a central right of assembly as a means of creating political change. Do you have a sense of, was it significant that they emphasized peaceable?
That's a great point, Jeff. Yeah, the word peaceable kind of stands out, right? You have this adjective, this adverb right here in the First Amendment saying, all right, it's not an absolute right. It has to be peaceful. And this is once again against the background of, of sporadic violence of mobs. You have the Boston Tea Party. You got, you have all these different officials being tarred and feathered. You have a good mix of peaceful and non-peaceful agitation for the colonists. So I think it's really important that that Peaceable is in there because the government has the power, that had the police power to restore order. They have the ability to make sure people aren't burning down houses and slaughtering each other on the streets in the name of their cause, in the name of addressing their grievances. So it's really interesting how the right to assemble is qualified like this. And peaceable, I think generally should mean the absence of violence. It means the absence of disruption, at least material disruption, substantial disruption. And it really creates a vehicle for the colonists and for the American citizens to bring their viewpoint to the government without causing public uproar.
That's a crucial point about how peaceable includes lack of violence. And we had a great podcast last week with Keith Whittington and Robert Post, who noted a bunch of Supreme Court decisions which emphasized the importance of peaceable assembly and repudiated the idea of the Hecklers veto. The mere fact that a group of the audience may not like what you have to say is not a justification for them violently shutting the speech down. Tell us about that.
The Hecklers veto is something we see a lot at FIRE, unfortunately. And it is when a group of people threaten violence against the speaker to prevent the speaker from talking, from having their event. It is also when universities or governments shut down the speech in response to those threats of violence. And this is really an issue because the First Amendment protects the right to talk, but also the right to receive information. And when people use violence to shut down speech and they succeed, that only incentivizes more violence. Likewise, when individuals agitate and violently protest and use these unlawful violent means to shut down these speeches and to encourage universities to censor the speakers, that will encourage more violence and less speakers. So the Hecklers veto is a really important concept here because it's something that we speak out against to ensure that the response to speech, even a speech that may be offensive or hateful, is more speech. The response to speech you don't like is not violence or censorship. It is always using your own words, your own facilities to counter that. So when we talk about the Hecklers veto, I'm trying to make the point that violence is not the answer. And when it comes to peaceably assembling, it must be peaceful. It must be something that does not disrupt the speaker or cause violence or harm the First Amendment rights of those seeking to exercise them.
Very crucial point, and you are dealing with it all the time in your work on campuses as we face the prospect of speech being shut down either by violence or by disruption that people don't like. So I think it would be great for our students to hear some examples of the cases you are dealing with and have written about so well at FIRE. And I'll just put a bunch of them on the table and you can decide which ones you think might be most illustrative. You've written about the Emory student government, which denied a student group the benefits of university recognition because the open discussion policy might mean the conversation could easily devolve and cause harm. And Emory University has now decided to refuse to recognize any new student groups for the foreseeable future. What speech and assembly issues does that raise? Yeah,
just some background here. Emory is a green light school. They're a school that has a great free speech culture, great free speech policies, and they're generally one of the few institutions in America that does this, that really has this wonderful array of policies and promises protecting students' free speech rights. However, they recently in December told a fraternity they couldn't hang Christmas decorations up, which was a bit of an issue, very Grinch-like of them. And now we have the situation where the student group that's focused on fostering discourse and open dialogue and debate on these contentious issues like race, immigration, affirmative action, and whatnot, what have you, they're being denied by the university, by the administration, the student government, because of their viewpoints. And this is a serious issue because the student government said to the group, we cannot give you recognition, we cannot give you the benefits of reserving rooms or requesting funding because of the potential for these debates to harm people, and actually required the group to get a mediator, to actually have someone in the group at their debates to I guess, condition the talk and to actually have somebody who can keep track of what they were saying. And the issue here is that that requirement was imposed on exactly zero of any of the other groups at Emory that the student government has recognized. And there's very clear policies in place saying how the university cannot deny recognition to the groups, cannot deny the benefits of this status based on the viewpoint of the group. So the student group is now going to present again to the university. We're trying to get the administration on board. And it's really a shame because of the many student groups out there, this is a group focused on free speech. And they're being denied the benefits of free speech because they're trying to have these debates. And this is also a law school. It's happening at the law school level. And so the notion that students cannot have debates about controversial issues that harming each other is pretty paternalistic and pretty infantilizing to these future lawyers.
Wow, that's a really important case to learn about. Another case you've been involved with recently is Cornell, which you say should reject proposed limits on freedom of association. Tell us what's going on there.
Yeah, at Cornell, many universities, we see limitations on groups choosing their own members, fashioning their mission statements. We see issues with these all-comers policies where forcing student groups to accept those that may not like their mission statement and may actually not want to do them harm. And the issue here is that student groups have the right to control the membership. They have the right to fashion their mission statement, as long as it's not discriminating on the basis of race, for example. And we see this issue very commonly with college Republicans, college Democrats, sort of political groups. They have the choice to have members who may have different viewpoints, who I think do what they do. But they should not be forced to accept members who may want to come in there and really disrupt the mission of the group.
That's such an important case. And in dealing with it, you cited the 1966 Supreme Court case of Evans versus Newton, which involved a controversy in Georgia over a tract of land in Georgia, which was reserved for a park for white citizens only. After the suit, the city desegregated the park, and Justice Douglas wrote, "A private golf club, however, restricted to either Negro or white membership is one expression of freedom of association, but a municipal golf course that serves only one race is state activity, indicating a preference on a matter to which the state must be neutral." What's the significance of that, and also the distinction between public and private action?
That's a great question. Thanks for bringing that up. The big distinction here is that public institutions, public schools, for example, are bound by the First Amendment. They are constitutionally required, legally required, to provide their students First Amendment rights, including the freedom of association. But private institutions, it's a private golf course, they're not bound by the First Amendment. They are free to follow their own dictates as long as they obey all other state and federal laws. We see this a lot with college campuses because state schools, like I said, it's non-negotiable. They have to obey the First Amendment. Private schools, they have to obey the promises that they make to their students. Many private schools in their mission statements require or promise their students the full array of free speech rights. And for us, it's a contractual argument saying if you're gonna have your students pay tuition, you got to give them class. If you're gonna talk the talk, you have to walk the walk. So we make it kind of a legal, moral argument with these schools, these private institutions, saying, look, if you're going to promise free speech, you got to deliver, even when it is unpopular or difficult to do so.
A legal and a moral argument. And if there's not a legal peg, then you hope that schools will just live up to their commitments that they make to their students to respect free speech.
Absolutely.
What's the argument on the other side? There are obviously strong forces in favor of the suppression of free assembly and petition, as well as association. And do schools openly defend the decision, and what terms do they do so?
I'm glad you asked that. I'm always happy to give voice to the opposing side. I mean, just a free speech, open debate, right? I was happy to have that discussion. The other side of that is that these private institutions have their own free speech rights, own First Amendment rights to fashion their own mission statements, to really further a certain set of values that may or may not be compatible with the First Amendment. For example, many religious schools, religious institutions, some of them directly controlled by churches, by religious groups, very clearly state in their mission statements, look, this is a university that puts these values above free speech. And that's okay. They have the right to do that. And students, we call these schools warning schools because students should be forewarned before entering the schools that they have lesser free speech rights as compared to a public school, for example. And that is acceptable. And we urge these schools to make their commitments clear, to make their mission statement's clear and to clarify to students who enroll in the school that these are the values that we that we believe in, that we want to uphold with our students. And so when students at these schools that don't have free speech promises are expelled or punished for expressing themselves, for speaking out, or for criticizing the church, they come to fire and they say, please defend my rights. We have to say, I'm sorry, because, you enrolled into an institution that does not promise them those rights, and we cannot hold institutions to promises that they don't make.
So that's a crucial question. Are the schools going to keep their promises? What about non-religious private schools that aren't formally bound by the First Amendment, but say they want to protect their students from being triggered or feeling unsafe or having their dignity assaulted or simply from hate speech? How are those arguments made, and how do they square with what the Supreme Court has said about the First Amendment?
Yeah, the big distinction here is the types of consequences that the First Amendment allows schools to impose upon students for their speech. Universities bound by the First Amendment generally cannot punish their students, cannot expel their students, suspend them, for example, for expressing themselves, for their political expression, for even very hateful expression in most circumstances. What they can do is they can educate them. They can have a conference. They can have a more speech approach. They can call students into offices and say, hey, we can't punish you for what you said on Facebook, but maybe you shouldn't do that in the future because it might affect your ability to get a job. These universities can counsel students. They can educate them. They can fill their role, which is expand their worldviews. We had a case in Kansas where a university would not accept the student, would not allow him to enroll because of his racist views, and we thought this was really awful because the purpose of university is to educate. It's to expand the worldview of students, allow them to understand the world around them and to expand their horizons. And for a school to give up on a student before they even enroll, to say, we don't want to have you here because, we think that your views are odious, it really insults the value of the school itself. Perhaps they're unable to change a student's mind, to make the student into someone who does not have these views. But the difference here, like I said, is between education and between punishment. And it's sometimes a fine line, is assigning a 30-page mandatory paper, education or punishment, right? To tease it out with fire. But schools have many tools at their disposal to deal with speech and expression that may be hateful, offensive, or annoying, that fall far short of suspension or expulsion.
Education is such a powerful antidote to evil counsels. As Louis Brandeis said, the best response to evil counsels is good ones, and teaching people to cultivate their faculties of reason so that they can be enlightened is always the best response. Tell us about some other, have you been successful in arguing that even hateful speech, which the Supreme Court has said is protected by the First Amendment, because speech can only be banned if it's intended to and likely to cause imminent violence, that even students who have expressed hateful speech can't be punished and shouldn't have their admissions withdrawn, for example?
We have. It's always a difficult case to make. Where a lot of times our letters to these universities are not just about legal arguments, but it's about the moral arguments, about the idea that the student may be misguided, they may be wrong, but they can benefit from a gentler approach. We have been successful. We have been trying to get administrators to kind of see our side and to perhaps reform their policies so that this doesn't happen again. And our goal here is to simply allow the student to continue the educational career that they've been on. It's allow them to not have the mark of being a harasser or being an awful human being on their record, and allow them to finish their careers and perhaps learn something new. I do a lot of fraternities. That's kind of my niche of fire, student groups, fraternities, and sororities. And we see frats do all sorts of, have all sorts of expression that many people view as distasteful or odious or hateful. And with the universities, look, you can expel the fraternity, you can expel the members, you can ruin these students' careers and really put a black mark on their resume, or you can have a workshop. You can have a seminar, you can have a conference, you can have a group come in and speak to the students involved and say, hey, maybe it's not a good idea to put these, derogatory and sexually explicit signs in your fraternity house. Of course, you have the right to do so under the First Amendment, right? It's not the worst thing we've seen a fire. but it may not be the best idea. And so we try to have a bit of a two-pronged approach of educating the administrators, also educating the students, both about limits of the First Amendment and about their rights.
Fascinating. Those fraternity cases are so important. Tell us about the Bloomberg University case, where you argued that they've made guilt by association the law of the land because violations of student rules can result in the punishment of their fellow students, and you cited the Supreme Court's NAACP versus Claiborne case. Yeah,
this is a fun case, not fun for the students, fun for us at FIRE, because of how egregious it is. This is Bloomberg right in PA System of Higher Education, public school, which had some issues with their fraternities and sororities, as many schools do. But instead of punishing the groups that actually committed misconduct, they decided to eliminate their entire Greek life system, and they decided to ban and revoke the recognition of every single fraternity sorority on campus. And we found that one of the sororities that they eliminated did nothing wrong. They're a local group. They had a clean display record. They're just going about their business, recruiting, fundraising, philanthropy, trying to, build strong generations of women. And they got a notice in the mail saying, because your group has Greek letters in its name, you are now no longer in the group. You've been eliminated from campus and revoked. And this strikes me as unjust, because the group is innocent. They did not commit any of the misconduct that many of the fraternities have done. It's like expelling the college Republicans because of what the college Democrats did, or expelling the chess club for what the gaming club did. It strikes me as very much a antithetical action in our system, because the First Amendment is very clear that guilt by association is not the law of the land. It cannot be allowed to stand. Plus, there's due process issues, right? Student groups have due process rights. They deserve a notice and a hearing and a way to contest the charge, just like students do before we kick them off campus. So this case, it was egregious to us because it was really a situation of students that had done nothing wrong being punished. And so we wrote to the administration, wrote to the general counsel, and they're unfortunately not budging here. So we're definitely exploring next steps here and seeing what we can do.
Wow, fascinating case. Well, I need to turn it back to Curry in just a sec for a few questions from our great students. But before I do, I'll ask you what you'd say to the students who are watching and learning from you about why it's important for them in their classrooms and when they go to college to tolerate speech and assembly that they may find distasteful or offensive.
Sure. I will quote FIRE CEO and President Greg Lukianoff when he says that the freedom of speech is a looking glass. It allows us to see the world for what it really is. We can't read minds. We can't figure out what people are thinking unless they say it, they express it, they use their free speech rights to show us. And I think when you hide from hateful speech, when you don't allow people to express themselves because it may be offensive or annoying, you're not seeing the world for what it is. And you may be blissfully ignorant of the world by only retreating to your echo chambers and being people like you, but you won't be any wiser, you won't be any safer. And it's always a good idea to explore people that disagree with you, to explore viewpoints that may be opposed to how you believe. That way you learn your own argument as well as your adversaries as well. So for seeing what really is, for being wiser, for being a more responsible citizen in our society, it's always a good idea to explore free speech, to explore those who have opposing views, and to uphold the rights of those who you disagree with.
That's such a powerful way of putting it that Greg Lukianoff does, that the First Amendment is a looking glass. It allows us to see the world as it really is. And I just need to take one follow-up, because we've been studying the philosophical basis for the First Amendment. One is that it will lead to the discovery and spread of political truth, as Justice Holmes said in his famous Schenck decision, and Brandeis in his Whitney's decision, that truth emerges in the marketplace of ideas, and that when different views are expressed, then basically truth will emerge. Another view is that it allows us to hold the government to account by saying what we think. Then our leaders have to listen to us and actually reflect our views. And a third is that it's part of our autonomy. Basically, the rights to think as we will and speak as we think are core to who we are as human beings, and that freedom to express what's in our minds can't be controlled by government or anyone else because it's inherent in who we are. Do you think Greg's notion of the First Amendment as a looking glass, is that the truth theory, that it's saying that actual, the truth will emerge from knowing what's in people's minds, or is it some other notion that when we know what's actually in people's minds, we can make up our own and basically make good decisions about what the truth is?
Right. I appreciate you quoting Justice Brandeis. I know that's a favorite scholar of yours, and it's always a pleasure hearing you read from his decisions and memorize them and have that knowledge. So I appreciate that. Yeah, I think it is a variation of the way to discover truth theory, in that the First Amendment allows individuals to be who they are, to express the true version of ourselves, and to see the world around us for what it is. And I think the discovery of truth is interesting because it does relate to how even when we're totally sure of our knowledge, it's always good to have some humility that we could be wrong. Even when we think that there's no possible way that my views could be mistaken or erroneous, it is always a good idea to just test out the opposing arguments to see if there's any cracks in my own logical foundation. So I think it is definitely a variation of the capital T truth, trying to figure out what a society actually is. And to do that, we need the widest range of views circulating in our society, because we can always be wrong. The settled truths of tomorrow may be falsehoods today, and vice versa. We always are evolving ourselves and evolving our conceptions of what truth is and what the world around us is. So we need the First Amendment to see the world and to discover truth, like you said.
Zach, you just said it so well. That was beautiful. You said it allows individuals to be who they are and see the world around us as it is. No one could say it better, including Brandeis. Being who they are is the kind of autonomy theory. We have the right to express what's in our minds because it is in our minds, and we can be authentic about that. And then see the world around it as it is, as you said, will allow us to form our opinions about truth with a sense of humility. And that part of it is so important that you stress that. Recognizing we may be wrong requires us to listen to people we may disagree with, including thoughts we hate, so that we can test our own ideas and ultimately be guided by reason. Thank you for so well encapsulating the core values of the First Amendment in such clear and memorable language. And thank you for your magnificent work at FIRE. And with that, I'm going to turn it back to Curry for just a few questions.
That was absolutely so much fun. And Zach, I don't know if you planned this, but you actually just wrapped up the entire last 3 weeks so well in that statement, because it really nodded to what David, that we talked about in the Free Speech Week, and understanding that you can, when you're listening to other people and when you're hearing other people, you can understand and see the bigger picture. So it reminds me of that fable about everybody looking at an elephant and nobody really understanding because they're just looking at that lens. But his point was, it was David French, his point was, and then it builds your argument because you can see what they're seeing too. So our teachers always share with their students, we want to ensure that you're seeing the world through lenses and mirrors. Mm-hmm. And that was a perfect summary of the last 3 weeks and why all these freedoms really jigsaw together and work together. I'm going to wrap it up with a question that we had from Kathy and Bonnie in the chat. And it really looks at the right to assemble and how it's connected to free speech and how it's connected to speaking to your community and your government. So when we think about free speech, and we've been recording our new Constitution 101 class all week, and all of us have been reading all these different pieces together. And I was really interested in a piece around the Virginia Ratification Convention, and it looked at the power of assembly, to the power of people assembling together to petition their government to change the government. It really referenced the Article 5, that people can come together in convention, assemble in convention. Mm-hmm. And so when we think about the right to assembly, sometimes we think about it in the right to convention. Probably less people think about it like that, to be honest. But we also think about it when assembling on the streets. And we saw that a lot in Philadelphia and around the country in the last few years. But we also think about it, the right to assemble with who you choose to assemble with, to come together. And I think about that in African American History Month and think about how that was denied to so many African Americans, the right to choose who you want to hang out with in church or wherever it may be. And so when you put that all together, and one of our staff members says, the right to assembly is who we are as Americans. The First Amendment is who we are as Americans. How do we understand that right in practice? And Kathy and Bonnie both brought up the conversation around Canadian truckers. And how does that play out in what makes it legal, what makes it appropriate? Because there are boundaries on the First Amendment, even in public streets. Yeah, so sorry, that's a huge one to unpack there, but it pulls in everything.
No, that's a great question. And thanks again, Jeff, for your kind words. I do have to, I can't take credit though. I do have to thank my team at FIRE, the scholars, lawyers here for helping me out, formulating these arguments and finding a good fight with me. But to your question, Carrie, yeah, it's just a matter of us living in a democracy. Numbers matter, right? Elections, votes, it's a numbers game. And, one vote, one person, one voice is not enough. You got to assemble people that think the way you do, that have the same political party, have the same viewpoints to really get your voice heard, to really get your point across in our society, which is about, voting and about these numbers. And there are ways to do this, right? There are ways to do this. Back then, it was very much all about in-person and writing. You have to literally deliver your petition to King George to get him to look at it, or if someone else do it for your behalf. And now it's all about the internet. A lot of petitions, change.org, right? There's one right now about Washington Avenue right here in Philadelphia. It happens every day about what issues are important to us as a community and as a nation. But to dig down into the issues here, it is about peaceable assembly. It's about doing this peacefully without disrupting individuals. One of the you bring up the Canadian truckers. I think one of the points of controversy here is that they are, or are they blocking traffic? Are they disrupting the economy? Are they actually preventing people from, living their lives and going about the orderly amount of their business? You have disputes about how disruptive this is and what they're doing. And most Americans, I think in a recent poll, don't agree that blocking traffic and disrupting, the flow of goods is a peaceable form of expression. And we can get into, what is peaceful and what is not. But I think the baseline principle here is that for expression to be heard and for expression to really have legitimacy, it must be peaceful. Once you invoke violence, once you use violent means to achieve your ends, you lose the protection of the First Amendment. And you can go back to Martin Luther King and even Gandhi having David Thoreau about the powerful force of civil disobedience, of nonviolence, of using the purity of your speech and of your viewpoints to achieve your ends. And so I think it's really important and really interesting that the framers did put that peaceable word right there in the First Amendment to show that only that sort of expression, that type of expression, will retain protection.
I was listening so intently, I forgot to unmute myself. Thank you. That was fantastic. And I love that you're bringing it back to the words. You're bringing it back to the original ideas around it and pulling in this right to gather together to make change, but also still protecting the minority and saying how voices need to be heard, even when they're not a large gathering group, and that it needs to be peaceable and it needs to continue to support the democracy. So thank you so much for wrapping up these 3 fantastic weeks. We appreciate so much you joining us. We're sending out information about FIRE. And also, Jeff, Zach is officially our youngest scholar ever on the Friday session. So I just had to say that because it's important for our students across the country to see scholars that look like them, and younger scholars are fantastic. So we thank you for all that you do, and also that you're just as brilliant and wonderful and can show the students that this can be achieved at every age. So thank you so much, not to embarrass you, but to make sure our students can see themselves in your work. Thank you, Jeff. Thank you, Zach. And Jeff, any final words to wrap it together?
No, I'll echo Curry's thanks to you for a superb and inspiring encapsulation of why the First Amendment matters. Thank you so much, Zach, and have a wonderful weekend all.
Thank you very much as well. I'm happy to be here and hope you have a great weekend too.
Great. Thanks, everyone. Bye.
Thank you, everyone. Thank you, Zach.
Take care.